I am Malvika Prasad, and in today's session, we will talk about the reservation quota proposed under the 103rd Constitutional Amendment Act of 2019 and attempt to analyze its constitutionality. To do this, we will discuss two questions. First, what is the purpose and principle behind reservations as understood under the Constitution of India? Second, would this particular reservation quota violate the basic structure of the Indian Constitution? Before we begin, let us understand what the 103rd Constitutional Amendment of 2019 proposes. This amendment empowers the government to create a reservation quota to the extent of 10% on the condition that the beneficiaries are not already protected by Articles 15 and 16 on the basis of their family income and other indicators of economic disadvantage. To answer the question of whether this reservation quota is constitutional, let us first understand how reservations were envisaged in the Constitution of India. The purpose of reservations, as envisaged under the Constitution of India, was meant to achieve two key things. It was to entitle every person, whether they belong to a political or numerical minority, representation in the governance and administration of this country, as well as a voice in the government and administration of this country. It was understood that barriers to representation and therefore barriers to expressing one's voice in governance arose from structural and societal barriers to opportunity, which is to say, social disadvantage such as those posed by gender, caste, and other kinds of systemic social power structures were seen as barriers to accessing opportunities on an equal footing. Therefore, in the framing of the Constitution of India, it was nobody's case that solely economic criteria such as family income be considered the basis of social backwardness. Of course, there were some disagreements on the floor of the House, but these disagreements assumed two distinct shades. The first was whether caste should be the sole determinant of social backwardness. So, for instance, Mahavir Tyagi, a member of the Constituent Assembly, proposed that occupational communities or classes of labourers be the beneficiaries of reservation, considering the nature of their labour. Another instance is Jerome K. D'Souza suggesting that beneficiaries of reservations be individuals, bearing in mind their individual setbacks as well as their social background. However, no one really proposed that economic criteria exclusively be the determinant of social backwardness. A second type of disagreement was on the nature of the remedy proposed. Perhaps alternative remedies ought to be considered, suggested some members. Economic safeguards and proportional representation were two such remedies. Ultimately, the Constituent Assembly arrived at the consensus that reservations would be the type of remedy that will be employed to remedy social backwardness. This was done in two distinct schemes. One, under Article 16, there would be reservations in seats and posts in government services for those socially backward communities that are inadequately represented in government. And the second type was in Articles 330 and 332 of the Constitution, which provided for reservations in Parliament and legislatures for the scheduled castes and scheduled tribes proportionate to their population in their respective states. These reservations were meant to ensure the representation of these numerical and political minorities. The basis chosen was caste or another kind of social backwardness, and the aim was to achieve substantive equality as opposed to merely formal equality. Soon after the Constitution was promulgated, the question of what ought to be the basis of social backwardness resurfaced in the floor of the first Parliament. When the first amendment to the Constitution was proposed to introduce Article 15.4 to the Constitution, K.T. Shah objected to providing reservations to scheduled castes, scheduled tribes, and other socially and educationally backward classes of people. He proposed instead that beneficiaries of reservation ought to be individuals and on the basis of economic criteria. This was the first articulation of an exclusively economic basis for reservations in the history of the Indian Republic. Prime Minister Nehru, however, objected to this proposal and stressed on the fact that social disadvantage encompassed a cumulative set of factors that included economic disadvantage. It was on this basis that Article 15.4 was finally introduced into the Constitution of India, empowering government to make special provisions for scheduled castes, scheduled tribes, and socially and educationally backward classes of people. Of course, then the question arose what socially and educationally backward classes would be. The first Backward Classes Commission attempted to answer this question using caste as the basis of social backwardness. However, the government rejected this report, and there was no list announced of socially and educationally backward classes. It was only when the second Backward Classes Commission published its report in 1980 under the chairmanship of Mr. B.P. Mandal that we had a sense of what socially and educationally backward classes of people ought to be covered by these special provisions. The Mandal report found that the genesis of social backwardness in Indian society was caste. They did this on the basis of an extensive ground study of the kinds of social backwardness faced by people. They found that social backwardness actually leads to economic as well as educational backwardness in India. The government went on to accept the Mandal Commission's recommendations with caste as the basis for social backwardness and educational and economic backwardness considered as compounding factors receiving a lesser weightage compared with social backwardness. When the Government of India applied the Mandal Commission report by way of introducing notifications, one other notification was introduced to have a quota to the extent of 10% exclusively on an economic basis for those persons who are not receiving reservations under the 15 and 16 framework and under the Mandal framework. This notification was the only comparable predecessor to the 10% quota proposed under the 103rd Constitutional Amendment. You will recall, however, that in the case of Indira Sahani versus the Union in 1992, the Supreme Court struck down that 10% quota, reaffirming the Mandal Commission's logic that social backwardness in India was born in the caste power structure. Therefore, there could be no 10% quota exclusively based only on economic criteria, the court found. In short, the logic of reservations in the Indian constitutional framework was to provide a remedy to realize substantive equality against social disadvantage or social power structures such as caste and gender. This brings us to the question of whether the present constitutional amendment's 10% quota is constitutional. Now that we understand that reservations is meant to achieve representation and voice for political and numerical minorities, we must ask the question whether reservations on the basis of an economic criteria will realize the same ends. The beneficiaries of the present amendment are many. The first category of beneficiaries are dominant caste Hindus. Why do I say this? The 103rd Amendment is explicit in the fact that it will not apply to those beneficiaries of Article 15 and 16 provisions as they already stood. Since dominant caste Hindus received no benefits under Articles 15 and 16, dominant caste Hindus will now be entitled to the reservation benefits of the 103rd Amendment. But what we find now is that in pursuing economic equality under the 103rd Amendment, we are further entrenching caste inequality by cementing the representation of dominant caste Hindus in educational or government spaces, even though these spaces are already disproportionately occupied by these members. Can that outcome possibly be constitutional? Now we know that several Supreme Court judgments have held that representative democracy is part of the basic structure of the Indian Constitution. But representative democracy is merely a facet of the form of government. Now the form of government means nothing if the substance of government is essentially undemocratic. That is to say, the prerequisite to realize a representative democracy is that all the citizens be free and equal. The substance of democracy, therefore, is that all citizens are free and equal, and that no constitutional amendment or law entrenches or sustains inequality in Indian society. So, to the extent that the 103rd Amendment entrenches caste subordination of some citizens by cementing the representation of dominant caste Hindus, it hampers the freedom and equality of those who are not entitled to the 10% quota on the basis of caste. This prevents us from realizing a representative democracy, and to that extent certainly can be said to damage the basic structure of the Indian Constitution. That is not to say the entire amendment is unconstitutional. Consider the other beneficiaries of this 10% quota outside of dominant caste Hindus. For instance, Christians and Muslims who are not listed among the other backward classes after the Mandal Commission, who are not listed as scheduled tribes, will be beneficiaries under the 103rd Amendment's quota. To this extent, this amendment is constitutional. Is there a way to do this amendment in a completely constitutional manner, that is to say, without reinforcing caste power? I would argue that that would be nearly impossible if reservations was the chosen tool of substantive equality. Why? As we discussed earlier, reservations is meant to realize representation and voice for political and numerical minorities. Now, those who are set back by economic disadvantage would need some other kind of remedy. They don't suffer from a lack of representation or a lack of voice, they suffer from other kinds of disadvantage that would be better remedied through special provisions that look like financial aid, tuition waivers, and such like. The Center for Research and Deep Debates in Development Policy has recommended that we might consider transgenerational and entrenched economic disadvantage as the basis for an economic quota such as the 10% quota in the 103rd Amendment. However, if reservations is the only remedy that is offered even to those who are set back by transgenerational and entrenched economic disadvantage, the remedy will not realize substantive equality. They will also need, in addition, remedies that look like financial aid and tuition waivers. Today, we have analyzed the constitutionality of the 103rd Constitutional Amendment's reservation quota. To do this, we first examined the logic, principle, and purpose of reservations as conceived of under the Indian Constitution. From the debates of the Constituent Assembly as well as subsequent parliamentary debates and the report of the Mandal Commission, we understand that the logic, principle, and purpose of reservations is to realize representation and voice in governance and administration for all political and numerical minorities. With this being the case, does this particular reservation on the basis of economic disadvantage damage or destroy the basic structure? We have analyzed that the basic structure of the Indian Constitution comprises representative democracy. Many Supreme Court cases have held this. However, representative democracy is merely a facet of the form of government. I propose that if the form of government is part of the basic structure of the Constitution, then the substance of democracy ought to also be part of the basic structure of the Constitution. Without free and equal citizens, that is, without a democracy in substance, can we possibly realize a representative democracy in form? I would think not. Therefore, to the extent that this amendment entrenches the caste subordination of some citizens by cementing the dominant caste Hindus' representation in governance and administration, this amendment can be considered to be damaging the basic structure of the Constitution. Thank you.